Welcome back to Savannah Car and Truck Accident Law with Andy Conn. I'm Brooke, sitting down with Andy Conn of Conn Law Firm in Savannah, Georgia. Today, we are answering the question every person hurt by a product eventually asks, what is a product liability case, and do I actually have a claim? We are walking through what makes a product defective in the eyes of the law, the three types of defects, why Georgia's strict liability rule changes, who has to prove what, who you can sue, what a case is worth, and the two deadline traps in Georgia that end a claim before it actually starts. So welcome, Andy. Excited to talk about this today. How you doing?
Hey, Brooke, I'm doing well.
Well, this is an exciting topic. So someone was hurt by something they bought and assumes it works like any other injury claim. In plain terms, Andy, what is the product liability case and how is it different from a regular injury claim?
We've come to expect our products to work and to be safe. I think a lot of people just assume that all products are safe because somebody has to be watching out for their interest when it comes to products. But in fact, it turns out that either companies aren't following regulations or there really aren't any protections or regulations in place. So a product liability case is just very simply when a product causes some sort of harm due to a hazard, a defect, or even perhaps maybe a lack of a warning or particular instruction that should teach you how to properly use that product.
So this might be a silly question, but what exactly is a product? And like, what do we define as a product?
It can be literally anything. So when we say product, we're talking about the cars you buy. If you're a hunter, the tree stand that you purchase. It can be the gas range that you're using that unfortunately explodes. It could be the pressure cooker in your house. It could be a child's toy. It's literally anything, any good that you purchase in this country that causes harm for some reason, you may have a product liability claim.
Now, I guess like when somebody thinks defective just means that the product broke. What does it actually mean for a product to be defective in the eyes of the law?
Sometimes it is when a product breaks, but other times it's when there's maybe a hidden hazard. It doesn't necessarily have to be something that breaks. A good example of this is I've had several cases throughout the years. I mentioned gas ranges, right? We take for granted that gas ranges are safe, but oftentimes they'll have features that cause gas to build up. And if that gas builds up for a long enough period of time in a confined space and hits another flame source, it can explode. And I've had several clients who've either perished based on that or have had serious burn injuries. And so that's not a broken product. That's just a product that the design was defective, meaning the design was created in a way that could hurt people basically without warning.
So that makes more sense then. Someone has heard there is more than one kind of defect, but does not know the different categories. What are three types of product defects: design, manufacturing, and failure to warn?
That's a great question. The design defect is not necessarily that something breaks, but there's some hazard that the company's aware of that could cause harm that they should have designed something so that does not happen, right? And we'll talk about this in a little bit, but in design defects, you can actually hold a company liable under strict products liability, meaning they don't even have to be negligent. Then the second category is a manufacturing defect. And what a manufacturing defect is, it means that maybe the design was fine, right? What should have gotten to the end user was okay. But what in fact made its way to the end user due to some manufacturing process wasn't that, or it was broken, or there was some quality control issue that led to the product not functioning as it's supposed to. Oftentimes we see that in tire defect cases, tire blowout cases. And then the third category, broad product liability category, is failure to warn, which here in Georgia, we have some of the strongest failure to warn laws in the country. And that just simply means sometimes you can't design a hazard out. Some things are just inherently dangerous. And sometimes it's not due to a manufacturing defect. But companies in those circumstances still have obligations to adequately warn you of a potential hazard in those particular instances.
We were talking about the failure to warn. So basically, the failure to warn would be when a company is negligent and doesn't warn users for potential damage. Is that accurate?
Yeah, that's totally right. And really, that's super important because, again, sometimes there's no way to design out some issue out of a product. And so there's different ways in which you're required to warn users. Sometimes it's in a user manual, but we know not everybody reads instruction manuals. So there's some warnings that if you don't put it directly on the product itself, manufacturers know that people aren't going to be aware of a potential danger unless they have that warning in very particular, conspicuous manner on the product itself.
So I want to hop back into like design defects and manufacturing defects. Someone can't tell whether their problem is in how the product was designed or how it was built. What would you say is a design defect? And how is it different from a manufacturing defect?
So when we talk about design, it's the process of actually coming up with the concept of a product. That's the design, right? And when the concept itself is flawed, that could be a design defect, meaning you need a better engineering schematic, or you need some sort of guard on a product to prevent someone from getting injured from the product. That would fall into the design defect. Whereas manufacturing defect is, even if the design is okay and they've designed a product that should be safe if it's created as intended, something about the process of making it is actually defective, meaning you don't put the right glue, for instance, on the product. Or maybe you're supposed to put some sort of sheath on it, and for whatever reason on the assembly line, that sheath doesn't make its way on the product. That would be an example of a manufacturing defect that can also expose a manufacturer to liability if you've been seriously injured or killed.
So the difference definitely makes sense in those. Hopping back into failure to warn, let's just say someone was hurt using a product in a way the label never warned against. What does failure to warn mean, and when is a missing warning label enough for somebody to win a case?
That happens so often. I've got several cases right now involving failure to warn. And it's not just the failure to warn about a hazard, there's also the failure to properly instruct on how to assemble a product. Those kind of go hand in hand in the same category. And so manufacturers are required to thoroughly test their products, and not only test the products on how they operate in a factory, but they're required to understand how the end user is going to use those products. And they do what's called a failure modes analysis, or at least they should, to determine in what ways the end user is going to misuse the product. And so they actually should know if there's going to be one of these ways that someone might do something that causes them harm. And in those instances, they have an obligation to warn that customer that, hey, don't do this, or please do this, or put together the product in this particular way, because if you don't, you could be seriously injured or killed. And you see that all the time with products, right? Failure to do X, Y, and Z may cause serious bodily injury or death. And definitely take a good look at those, because when they're warning you about that, it's because they've been made aware of some danger that you need to be made aware of to safely use the product.
Now that defects are on the table, the next question is who has to prove what? And that is where Georgia law tilts the field. Someone keeps hearing strict liability and does not know why it is a good thing for their case. What is strict liability, and why does it matter that Georgia recognizes it?
Let's go back to a car wreck, right? If somebody runs a stop sign and hits you, we're familiar with the term negligence. It's negligent to not obey a stop sign and to hit somebody in a motor vehicle collision. In the product liability context, you do, for design defects, that first category we talked about earlier, have what's called strict product liability, which means you don't actually have to prove that the company was negligent. All you have to prove under Georgia law is when that product left the manufacturer's plant, the design that it left with was defective or had some ability to harm the end user. And so we have a real advantage in those particular types of cases, because you don't actually have to prove negligence. You just have to prove that there is a defect.
And now someone assumes they have to find a careless decision inside a company they will never get inside of. Do you have to prove the manufacturer was careless, or just that the product was defective?
Yeah, for strict products liability, for the design defect side, you do not actually have to prove that the manufacturer was careless. All you have to prove is the product that they sold was defective.
So someone is trying to understand why their lawyer keeps using two different words for the same case. What is the difference between a product liability claim and an ordinary negligence claim?
Sometimes with product liability, you still have to prove negligence. And those manufacturing defects or in a failure to warn claim, you do have to prove some level of negligence. But usually, typically, ordinary negligence, that's a fancy legal word. Ordinary negligence just means that somebody didn't act prudently in some situation. So again, it could be you run a stop sign or you do something that causes someone else harm that you shouldn't have done. That's essentially what negligence is. But for products liability, in some contexts, you don't have to prove that anyone necessarily did anything wrong. You just have to prove that the product itself was defective. I will say in practice, when you're actually litigating these cases, though, you still have to present these to juries. And so still oftentimes we're working on what could have the manufacturer have done differently. So even though they might be strictly liable for that product, we still want to be able to show, listen, there's other products on the market like this that are safe. And you didn't take a look at those, or you didn't try to look at the marketplace to see, is my product not as safe as the other products on the marketplace? So even though you don't technically have to prove negligence, oftentimes in product liability cases, we still are able to show that manufacturers did something wrong.
Now, I'm just curious, why would somebody plead more than one in these situations?
It's important to have a lot of different options. And this is getting pretty highly technical, but when we file a lawsuit against manufacturers, we don't know what all the facts are going to be. We don't know what internal documents and emails and schematics and all those things that they might have. And so we want to give ourselves the ability to bring any number of different types of claims against a manufacturer or a retailer or any other company in the supply chain, so that once the facts come out, then we can narrowly tailor it to what the facts actually show before we go to trial.
Someone's afraid that the company will blame them for how they used the product. Can a defective product still be the manufacturer's fault, even if you were using it normally?
Absolutely. And I'll say that almost always the manufacturer is going to blame you for doing something wrong, even if you didn't do anything wrong. There are instances where I have clients that maybe they didn't do everything exactly the right way, but that doesn't excuse a manufacturer from acting prudently, right? And one thing to think about is you might make a snap decision at a particular time without a whole lot of context, right? And sometimes we don't always do things the right way as human beings, but manufacturers have years, oftentimes decades of data and experience and knowledge that they still oftentimes ignore. And that's when products become dangerous, is when they ignore those signs. They don't warn their customers, or they don't recall products when they know they should, or they send out an unreasonably dangerous product on the marketplace because it would cost more to take it off the shelves than it would be to save a life.
Now, this is something that I can see happening for me. I know the store that I bought it from, but I don't know who made it. Who can you sue? The manufacturer, the seller, the distributor, or all of them?
Like with anything in the law, and especially in Georgia, that's going to be heavily fact dependent. So there are instances where you can sue every single one of those companies that are in that supply chain. In Georgia, though, for a strict products liability, for that design defect thing that we talked about earlier, the only people you can sue for the strict products liability are the manufacturer, so the people who actually physically make the product, the designer. Sometimes that's the same company. Sometimes there were other companies who design the product before it's made. And thirdly, the assembler. So whoever puts the product together after it's manufactured and designed. Those are the three that you can hold liable for strict products liability. But you can still hold liable distributors, retailers, or anyone else in the supply chain if they had notice of a defect and didn't do anything about it, or if they had knowledge of a hazard that they didn't warn against. They're still obligated to warn their customers when they know about a danger. And in Georgia, like I mentioned earlier, we have some of the best failure to warn laws in the country. And that's because in Georgia, even after you sell the product, manufacturers and retailers have what's called a continuing duty to warn. So even after they sell it, if they then realize there's a hazard, they have to notify the people that they've already sold the product to of that issue. Not every state has that, but it's really important and makes Georgians safer that we have those laws here.
Absolutely. Georgia's a great place. Now you know what a defect is and who answers for it. The next layer is how you actually prove it and how a recall fits in. Someone has heard warranty only in the context of a receipt and a return policy. What is the breach of warranty and how can it give you a second way to win?
So breach of warranty is essentially, it's a little bit different. Sometimes it's intermixed with the product's liabilities, the design defects and the manufacturing defects. But essentially what that means is if a company says our product will work in X way, and then it doesn't work in the way that they warrant it or represent that it's going to work, then you might have a breach of warranty claim. So practically how that works a lot of times is, let's say a company says that a particular product on their website can withhold 300 pounds, and anything 300 pounds or below will withhold and won't break. And you put a 250-pound person on the product and it breaks, that would be a breach of a warranty, because not every product is intended to withhold 300 pounds. So it's not necessarily defective that it can't hold 300 pounds. But if you tell the product user that it can hold 300 pounds and it can't, that's how people get really hurt and that's how people die.
That's actually a really good example to explain the situation. Now, someone wants to know how a court actually decides whether a design was too dangerous. What is the risk utility test Georgia courts use to decide a design defect case?
Yeah, the risk utility. So it's basically exactly what it sounds like, right? And we as a society have come to understand that there are certain risks we're willing to take that we know are going to hurt people. That doesn't necessarily mean that a product is defective. So we know, for instance, that cars are going to kill a lot of people. But we don't say that cars just in and of themselves without something more are defective just because they go at fast speeds on the highway. And so essentially what the risk utility test is trying to decide is, what value does the product have? Is there a way to make it safer? And if not, what's the utility of it, right? If it's got high utility like a car, it's not going to be defective to sell that car on the marketplace. Now, if that car doesn't have airbags that deploy quickly enough, it could still be defective. But we have, as a society, and in Georgia in particular, have decided there's some things we're just comfortable being unsafe on the roads or in our homes. And that's what the risk utility question asks, and what a jury ultimately has to evaluate in deciding, is this product defective? And is it so defective that we're either comfortable or not comfortable having it in our homes?
Absolutely. I had never heard of the risk utility test. So that's a really interesting concept. Now, someone is worried it will be their word against a corporation's. How do you actually prove a product caused your injury?
In some instances and in some of the facts, it is going to be your word about what happened, because sometimes there are cameras that catch incidents. Oftentimes there are not. I have several tree stand defect cases, and the folks who got hurt in those tree stands were out in the middle of the woods and there are no cameras. And so a lot of the evidence we have is what they testified, or what, if they're with a friend hunting, what the friend testified happened in those particular cases. But that's not all we use in a product liability case. We have to fight like hell in product liability cases because manufacturers don't want to turn over their documents. They don't want to show us their emails where they're talking about knowing risks of dangers that they don't pass along to the customers. And so we fight like hell to be able to get all of those records. It's not just about the day of the incident. It's about the years and decades of knowledge that the manufacturer had that they didn't use in designing a product, or at least didn't pass along to the consumer who would be using that product.
Are experts brought in to examine the product at all and figure out if the defect could have happened, or like how the defect happened ultimately?
Absolutely. Probably more so than any other type of case. Experts are incredibly important in product liability cases. It depends on the type of case, but usually you're going to have a design expert who can actually go through and talk about other feasible designs that they could have used that they did not use. Oftentimes you'll have an accident reconstructionist or a biomechanical engineer who will come in and say, here's how, based on the forensic evidence, the accident actually happened. Here's how this person fell, or here's how the crash in the vehicle happened when the airbag didn't deploy. And if the airbag would have deployed in time, here's how it would have protected that person from having a brain injury or from dying. And so you use those a lot. We talked about these in other episodes as well. A lot of times you're going to be using medical experts too, because you have to explain the severity of things. And so you might use physicians, you might use life care planners, who we talked about in prior episodes, can help you piece together, what's it going to cost me and my family to live this new lifestyle for instance, if you're paralyzed over the course of time. And so, yes, we use a lot of experts. Another really important expert, depending on the type of case, is called a human factors expert. Those are experts who can help explain how individuals actually use the products and how they're going to fail given the normal use of a normal individual. And those are typically the main ones, but depending on the case, you could have even more than that.
I want to switch it up and talk a little bit about recalls. So let's just say someone saw their product on a recall list and doesn't know if this is good news or if this is bad news. Does it help your case if there was a recall, or would you say that it hurts your case?
It depends, right? Anything in the law, it depends. So if there was a recall and you had notice and knowledge of that recall and you didn't do anything to take it off the shelves or to bring it in to get it fixed, then a recall could potentially hurt your case, because in those instances, you didn't heed one of the warnings from the manufacturer. Oftentimes, their recalls are very good for your case because it does two things. First, it shows that you're not just making this up. This didn't just happen to you. This is an issue that's happening across the country. And oftentimes what we find is once a manufacturer knows that this has happened 1, 2, 10, 30, 50, 100 times, oftentimes they still won't recall the product. And that's a huge issue for the manufacturers. And they're basically taking their own profits. They're putting their own profits ahead of consumer safety. And so in those instances, it might actually entitle you to punitive damages. And so oftentimes we look for recalls. That's an important thing that we investigate on the front end of any product liability case is, was there a recall and how good of a job did they do communicating that recall to the public?
Yeah, that's interesting that you say that, because I feel like there's been products that like I found that I was using, I found that it was recalled only from a Facebook post. Like I never received a call from the store that I bought the product from, even though I had to put my phone number in when I buy that product. So you'd think that they would call you. It's interesting that you bring that up, because I can assume that there's many cases where it's not being communicated with.
That's right. And in Georgia, again, we have a continuing duty to warn. Not every state has that, meaning even the retailer. If the retailer knows that there's a problem with the product, if the manufacturer knows there's a problem with the product, if the distributor knows there's a problem or a hazard with the product, they have an obligation to do everything in their power to communicate that warning to you as a Georgia citizen.
Now, someone has heard about huge verdicts and wants to know what unlocks them. When are punitive damages on the table against a manufacturer?
That's a great question. And so in Georgia, typically punitive damages are going to be capped at $250,000. That's the law that our legislature decided to pass. But for products liability, that does not apply. There is no cap on how much a jury can apply to punitive damages for a product liability case. So oftentimes what we do is we get evidence of the profits of a corporation. Big corporations like, for instance, Ford or another type of large corporation, one thing you can show is that at times they had knowledge a long time before an injury occurred that this was going to, or likely was going to happen, and that they didn't do anything to fix the issue. They didn't do anything to warn. In those instances, they might be liable for punitive damages. And that's something a jury, again, does not have any cap on how much they can award. You might see at times really large punitive damages awards. We've had 9-figure, meaning over $100 million, just on the punitive damages side on some cases here in Georgia. By the way, one thing most people don't realize for punitive damages, 75% of the award of punitive damages actually goes to the state of Georgia for the benefit of the citizens of Georgia. So it doesn't actually even go to the plaintiff. Only 25%, 1/4 goes to the plaintiff. The other 75% goes to the state of Georgia.
Interesting. The more you know. I definitely did not know that. That covers liability and proof. The last beat is the part people most want to know: what a case is worth and how long they have to act. Someone only thinks about medical bills and does not know what else counts. What kinds of damages can you recover in a product liability case?
Yeah, just like with any other personal injury case, you're entitled to recover your medical bills to some extent. Typically, the cases that we handle that are product liability cases are going to be catastrophic injuries or deaths. I personally, and not every lawyer thinks this way, medical bills are important, and I understand that people don't want to incur them and have to pay them back. But that is the absolute smallest portion of what I believe is important to talk to a jury about in terms of what are your damages? What are your harms and losses? Because $1 million in medical bills pales in comparison to the inability to hold your grandson or the inability to play the sport that you once loved. We would all give up money all day long to be able to pursue the things that make life valuable. And so what I typically focus on in a product liability case is not those medical bills. It's the things that you've missed out on and that you're currently missing out on. Or if you've passed away and your family members have brought a lawsuit, what would have been meaningful to that person? What moments, what graduations, what weddings did they miss out on? That's the important thing, especially for product liability cases.
The non-economic piece seems to be most valuable for most families. If a family lost someone and does not know if they have any standing at all, if a defective product kills a loved one, can the family bring the claim?
Absolutely. And in Georgia, we have what's called the Wrongful Death Statute. And that's an act that was passed that affords the heirs of a particular individual for bringing a claim. And so the way it works in Georgia is if you're married, your spouse has the right to bring a claim against the product manufacturer. If you're not married, but you have kids, your kids are the ones who are the beneficiaries who are able to bring a claim for your death. And then it kind of goes down from there. It goes to your parents, your siblings, different family members. But suffice it to say that, yes, if you're a family member, there is someone who has a claim to that wrongful death action. But usually you need to consult with an attorney to decide if you're the family member who has it, or who might that be?
Okay, got it. Now, someone wants a number and has only seen headline verdicts. How much is a product liability case actually worth?
I get that question all the time. I get clients who come in and say, my case is worth $10 million because I saw another similar claim that settled or had a verdict for $10 million. The hard thing is that there's so many different factors that go into what are 12 strangers on a jury going to decide your case is worth. Right? Every jury is different. Every venue is different. Every plaintiff is different. And even if the defect is the exact same, the way that it occurred might be different. One case, you might have the person who got hurt might have done nothing to contribute to the harm. In another case, the person might have been doing something that also contributed to it. So there's a ton of different factors that we look at. And I always have a very honest conversation with my clients about valuation. Just because you see something in the news doesn't mean your case is worth that. Your case might be worth more than that in some instances, right? But oftentimes it's going to be worth less because there are factors about your case that are different than the other person's case.
Yeah, absolutely. I think it's just really important to remember that every single case is very different. We all drive down the freeway and we see the billboard that gives us an idea of what we would win in a case, but we just need to remember everything is very different. Now, someone assumes they have plenty of time and has never heard of a second harsher deadline. How long do you have to file a product liability claim in Savannah, Georgia? And what is the statute of repose?
That's a very great legal question there, Brooke. So typically, just like any other case, there's first a statute of limitations, and that is 2 years in the state of Georgia. So typically, 2 years after the injury occurs, that's how long you had to file your lawsuit. If you don't, you're not going to be able to bring a lawsuit. Sometimes there are instances where that 2-year statute of limitations either doesn't apply or it's delayed or what we call tolled. In those instances, you might have more time to bring an action. But in Georgia, we have, not every state has this, a very tricky statute, as you mentioned, called the Statute of Ultimate Repose. That is 10 years in Georgia. So here's a real life example, right? Let's say you buy a car that was manufactured in 2014, okay? And you get in an accident in that car in 2023. So 9 years after the car was manufactured. Typically, you would think, well, I have until 2025 to bring this case because of that 2-year statute of limitations. But unfortunately, because of the statute of repose, you have 10 years from the date of manufacture of the product, meaning in 2023, you might only have until 2024 to be able to file your strict products liability claim. Okay. Now, a couple of exceptions to that, as there are always exceptions. If the manufacturer was grossly negligent or reckless in their design, then the statute of repose might not apply in those circumstances. Also, the statute of repose of 10 years does not apply to failure to warn claims. So even if you're listening to this podcast for the first time and you realize Maybe you have 6 months left on your statute, but the statute of repose, it's been 10 years since the manufacturer date. There are still options, but you definitely need to have it thoroughly vetted by an experienced product liability trial attorney who can help advise you on whether you still have claims that can be brought.
Got it. Well, we're talking about what we should do. Let's just say someone suspects a product hurt them, but is paralyzed about what to do first. I think that can be something that happens to a lot of people. It's what next? If you think a product hurt you, but you're not sure you have a case, what is the very first step?
This is so important. And we've talked in other episodes, Brooke, about things you should be doing after an accident. The number one most important case that you have an obligation to do something is in a product liability case, because the number one thing you should do is preserve that product. If you don't have a product, oftentimes you don't have a case. There are some exceptions to that. There's sometimes that there's an ability to be able to bring a case, but oftentimes you have to have that product because we have to be able to test and prove that product actually failed in the way that we're alleging that it did through expert testimony and expert testing. And so absolutely the number one important thing is preserve the product, keep it safe, make sure nobody destroys it.
I'm assuming too, to keep that product the way that it was, like don't make any changes to it, don't move it. I would assume that's very important.
You don't want to alter the product in any way that you can help. Now, listen, when bad things happen, and I've had cases where people are paralyzed and they're sitting in a hospital bed, right? There's nothing they can do to preserve the product, right? They might be in a coma, that somebody might have passed away. We understand there are circumstances that make that more difficult. But if you're listening to this and you have a product liability case, and perhaps you can't get to where that product is, get a friend or a family member to go preserve that product for you because it is incredibly important.
Absolutely. That is a full picture of what a product liability case is and whether you have one. Last bit is one piece of advice on how to reach Conn Law Firm. Before we close, Andy, can you give the person listening right now one piece of advice that they can act on today? I know we just talked a little bit about that, but I want to hear what's the number one piece of advice that our listeners can act on.
From a safety perspective, before anything happens, you definitely want to be paying attention to those warnings, right? If a manufacturer does the right thing and actually gives you those warnings, pay attention to those because it's probably because somebody in the past has been harmed by something that wasn't on the product at that time. So please, I hope you never need me as an attorney because I hope that you don't get seriously injured or your family members aren't killed due to a product. But my number one piece of advice would be pay attention, be safe. After something bad has happened, my number one piece of advice would be call an experienced trial lawyer who actually has results with product liability cases. It's very important. You might see people who don't have any very good results, or maybe they have good results in medical malpractice or in car wreck cases. If they don't do products liability, you need to reconsider potentially who you're using because these cases are highly complicated. They require substantive experience in these particular areas. So definitely vet your attorney, pick the right trial attorney who can represent you on those cases.
If you or a family member was hurt by a product you believe was defective in Savannah or anywhere across Georgia, call Conn Law Firm at 912-373-8642 or visit connlawfirm.com to talk to Andy Conn directly. The consultation is free. Thanks for listening to Savannah Car and Truck Accident Law with Andy Conn. We will see you on the next episode.